muted, so you will be unable to verbally ask any questions to the presenter. If you would like to ask a question, you may do so by using the on-screen webinar sidebar panel to the right of your screen where the questions box is located. Just type your question in, and we will answer as many questions as possible at the end of the presentation. You can also locate a copy of this presentation under the handout section in the webinar sidebar panel. Today, we are pleased to host Jamie Hedgepath, an employment and labor law specialist with Nexen Pruitt. Today, he will discuss managing your workforce during the COVID crisis and navigating employment and labor laws in this unprecedented time. Jamie, welcome, and thank you so very much for being with us for our Greenwood business representatives. We'll turn it over to you.
All right, well, thank you. It's a pleasure to be with you this morning. As an employment lawyer, this is kind of unprecedented times for me, just like it is for a lot of you. I will say that I've done, I think, a record number of webinars over the last couple of weeks. Let me say one thing, just a little bit of housekeeping about your PowerPoint. This is something that I've prepared in anticipation of today. I had a call yesterday with Janet and with Austin around 4 o'clock, and I had presented the PowerPoint to them at that time. And then after that, the world kind of went crazy for a little while with a lot of new guidance from several avenues, from the governor's office, from the CDC, from OSHA, and then one little lawsuit that I want to talk about briefly. So what I've done is actually add 5 or 6 slides at the beginning of the presentation, and I'm going to go through those slides. You don't have them, but I will make sure that I get those sent down to Janet so that they can be circulated later. And then some of the CDC guidance actually changes one of the hypotheticals that we're going to work through, and I think it's a fairly important change. So we'll talk about that, and if you have questions about it toward the end, we can get into that. I'll tell you, I tend to be a slow speaker. I have a hard time getting through my slides, and with adding these additional ones, that means I'm probably going to get behind a little bit. If that's the case, I'm probably not going to spend much time covering the FFCRA slides that are in the PowerPoint, but if you have questions about that or really anything else related to this, I'll be happy to try to answer those at the end. So what I want to do for the first maybe 5 or 10 minutes is talk about what happened yesterday, really after about 4:30. The first thing I want to talk to you about, and if you'll make some notes, a lot of this information you can pull up online after the webinar and get some additional information. But yesterday, the CDC issued some guidance that really was quite a bit different than what we've heard for the last 4 or 5 weeks. Late yesterday, and I'm going to read some of these slides because a lot of it's still new to me, but basically the CDC is now saying that for your employees following exposure or possible exposure, if they are in what are considered critical infrastructure industries, and I talk about that on the next slide, those workers can be allowed to continue to work following that exposure, provided they remain asymptomatic, meaning they don't have a fever, they're not coughing, that kind of thing, and as long as the employer follows these precautions that I've listed here. And they're fairly, they're practical to make a lot of sense, but it is different than what we've been hearing. Employers should measure temperature and assess symptoms prior to starting work, and the CDC has also said they'd like to see that happening before the employer enters the facility. As long as the employee does not have a temperature or symptoms, and primarily there we're talking about fever, cough, but there are some other symptoms that you'd want to be on the lookout for. I know it's challenging during allergy season. The employee should self-monitor under the supervision of, and this is language specifically from the CDC publication, their employer's occupational health program. So basically monitoring that with you keeping a watchful eye over that situation. You certainly still want to encourage, if you're in one of these critical infrastructures and this guidance applies, you still want to encourage your employees to self-report exposure or possible exposure to the virus. The employee should wear a face mask at all times while in the workplace. for 14 days after the last exposure. I know that some employees are wanting to wear face masks in the workplace now. Some employers are encouraging that, maybe even requiring that. The guidance indicates that the employers can issue masks or they can approve employee-supplied cloth face coverings in the event of shortages. CDC hasn't issued guidance, or at least I don't believe they've issued clear guidance yet about how an employer would evaluate a cloth face covering. So I kind of have to take that for what it's worth. Continuing to practice social distancing. Hopefully you're doing that in your workplaces anyway, regardless of this guidance. And then disinfect and clean any workspaces on a regular basis, offices, bathrooms, common areas, break rooms, things like that. Continuing on with this guidance from the CDC, there are a couple of definitions that I think are important. Potential exposure means, and this is from the guidance, being a household contact or having close contact within 6 feet of an individual with confirmed or suspected COVID-19. So that's a pretty broad definition, and does give employees and employers a fair amount of leeway to try to get critical employees to remain in the workplace as long as they're asymptomatic. And then critical infrastructure includes, and this is not an exhaustive list, but it does include these items, these that I've listed here: law enforcement, janitorial and custodial staff, workers in food, agriculture, critical manufacturing, IT, transportation, and energy industries. If an employee, the guidance does say that if an employee does exhibit symptoms, you need to send them home immediately and clean and disinfect the work area. Again, practical advice, but it is important to note that the CDC does say if they do exhibit symptoms, to send them home immediately. Another development we had from yesterday, late yesterday, the governor's office issued another executive order. This came as a little bit of a surprise, but I think it is in response to a lot of employers not really knowing how to handle maybe paying out PTO to supplement unemployment or providing some type of severance benefit to try to help employees stay afloat while they're drawing unemployment. But basically this order doesn't have this title, but it's just in the order, there's a reference to authorization for COVID-19 support payments by employers. The guidance allows employers to make these, quote, COVID-19 support payments to furlough, job-attached layoff employees without impacting the employee's eligibility for unemployment benefits. That is a question that we received a lot early on with the COVID-19 crisis. The payment can be a one-time payment, or it can be a series of payments over a period of time. And there was a lot of emphasis in the order that it has to be for services rendered in the past. In other words, an employer making this payment does not have an expectation that the employee will repay any of this money going forward or will come in and work as consideration for receiving the payments. You know, one of the questions that has popped into my mind is how do these payments, how are they handled from a PPP loan standpoint? My position on that right now would be that they would not be considered wages eligible for inclusion in a PPP loan forgiveness scenario. We'll touch on PPP loans maybe a little bit later. The order requires that the payments be made pursuant to a plan that the employer provides to Due on a form that Due will prepare and publish on its website. I've not been on the website, but I suspect that form is not yet ready, even though, as you'll see on the next slide, this executive order took effect immediately. The payments are classified as a form of severance pay, which means that it is not considered wages under the South Carolina unemployment statute. That also means that it's not considered wages under the South Carolina Payment of Wages Act. The plan that is talked about in the executive order and that Due will be expecting employers to submit to them if they're making these payments must include information about the length of the furlough. In other words, how long do you expect the employee to be out? They must state the amount of the payments that will be made. I suspect that employers are going, that may be a fluid process and that those payments may change. Obviously, we haven't received any guidance yet from DUE, so we don't know how flexible that will be, but I suspect there'll be some flexibility allowed for employers. The plan has to identify each employee that's going to receive one of these payments by name, and then include this attestation by the employer that it's not making the payments as a form of remuneration or consideration for the employee's performance of services. It's essentially a way for an employer to try to help employees get through the next few weeks or maybe month or two without it impacting the employee's ability to obtain unemployment benefits, both the state piece and the federal piece. One additional requirement, and this is something you've been hearing about for the last few weeks, but there is in the order a provision that states employers shall file employer-filed unemployment insurance claims according to guidance provided by DUE for each employee receiving COVID-19 support payments. I interpret that to mean that employers who are not already submitting claims on behalf of their employees will now have to do so when they are providing these payments. Of course, even when you file those claims, the employee still has to go to the DUE website or submit a paper application to DUE for their benefits. And as I mentioned a moment ago, this was effective immediately. Something else we heard about yesterday afternoon, there was an OSHA press release. This was almost comical to me because it's just not very timely. But just this is from the press release. It says that the release is reminding employers that it is illegal to retaliate against workers because they report unsafe and unhelpful working conditions during the coronavirus pandemic. And then it lists these acts of retaliation. The press release actually provides a link to OSHA's online whistleblower complaint form so that an employee can easily and readily submit a whistleblower complaint. Seems like the DOL could spend its time helping us out a little bit more with some guidance as opposed to issuing these kinds of press releases, but I don't want to say too much about that because I know it is kind of an unprecedented time. One more thing we saw yesterday is actually a lawsuit that was filed on the 7th. There is a South Carolina code provision. Not a lot of states have this provision, and you guys may or may not be aware of this, but this code section falls under the Emergency Health Powers statute, and it states an employer may not fire, demote, or otherwise discriminate against an employee complying with an isolation or quarantine order issued pursuant to the South Carolina Emergency Health Powers statute. However, nothing in this section prohibits an employer from requiring an employee to use annual or sick leave to comply with such an order. I don't think this statute is anywhere near the top of any employer's concern list right now, but it is something you need to be aware of. We did see a lawsuit filed out of a plaintiff's law firm down in Columbia on Tuesday, and I'm just going to walk through these alleged facts and real quickly, and then we'll move on to the rest of our presentation. But the lawsuit alleges a violation of the statute that I read a moment ago. The plaintiff worked as an LPN charge nurse at a nursing home. She allegedly had contact with an aunt who had contact with a COVID-19 patient at another healthcare facility. The plaintiff, just an additional fact, she indicated, according to the complaint, to her employer that she was not sure when that contact occurred, whether it was before or after the aunt had contact with the COVID-19 patient. Pursuant to what we were seeing in the CDC guidelines until yesterday, the defendant sent the plaintiff home for a 14-day quarantine. She asked if she would be covered by the FMLA. I believe she probably asked if she was going to receive paid FMLA, but she would not have been eligible for that. She also wouldn't have been eligible for the emergency paid sick leave under this scenario. She eventually learned that the aunt tested negative and asked her to come back to work. The defendant in the case, the nursing home, was allegedly not happy with the way that plaintiff had reported the information to them early on, and also for the first time raised attendance concerns. I will tell you, as an employment litigator, it's I never get excited when I hear about something being raised for the first time, if that's going to be the basis for termination, but that's what happened allegedly in this case. It's not clear to me in the lawsuit what quarantine order the plaintiff was allegedly complying with. I think there's a big hole in her case there. But there is a lot of gray in the lawsuit. She's seeking lost wages, lost benefits, and punitive damages. Don't be surprised to see more of these kinds of lawsuits arising. This is an area that's going to be ripe for the picking for plaintiffs' lawyers, primarily because there's just so much uncertainty in the law. And I don't know how many times I've said over the last 3 or 4 weeks that I feel like I've been drinking it, and I'm sure you guys do too, from a fire hydrant, and trying to digest all the information. We could, our webinar today could go for several more hours just trying to cover a handful of these things. So with all that said, let's move to what you guys have. This should be the third slide of your presentation, and I'm going to run through some of these pretty quickly. I've listed the topics that I want to cover here. The home or work order was issued by executive order of the governor, took effect on April 7th at 5 o'clock. I worked from home Monday, Tuesday, and Wednesday of this week, came to the office today, and traffic didn't look a whole lot different to me driving to work. I don't think that folks are really looking at this as a stay-at-home order, and also don't know how strictly it's being enforced. A lot of broad exclusions in the order. The order does state that folks should be staying home unless they are working, visiting family, exercising. That's a pretty broad definition. Caring for pets or obtaining essential goods. If you skip down to the 2 bullet points, engaging in outdoor exercise or recreational activities includes related travel. So that could be anything from going to the park for a hike. It could be getting out for a jog. It could be somebody wanting to go out and hunt or fish, anything like that. The order does indicate that social distancing should be practiced. I'm not going to get into what the order says about church, but there has been a lot of discussion in local media and of course social media about what the order says about church. A violation of the order is a misdemeanor subject to 30 days in jail or a $100 fine. I've not heard of any incidences of either of those happening yet in South Carolina, and I'm hopeful we don't see a whole lot of that. Essential services, essential critical infrastructure workers. We kind of got into that a little bit a moment ago with the CDC guidance, but I've listed these here for you. And it's really what you would think of as in terms of what folks' daily needs are. However, there are a lot of professional services that are listed in here that are not listed in here in this list that this would apply to. For example, legal services, things like that. This is a list of non-essential businesses, in other words, the types of entities that are closing. And I will say that a lot of these types of entities are clients of mine. So there's been a lot of work dealing with FFCRA issues. There's been a lot of work dealing with furloughs and layoffs and unemployment. And we'll talk about a lot of that stuff as we go forward. I don't expect this list to change a whole lot unless we see things, unless we see the virus numbers take a significant uptick in South Carolina. All right, March 9th, 2020. And so we're going to talk about safety and health, and primarily here we're talking about OSHA type stuff, but there's some DHEC guidance out there as well. But back on March 9th was a month ago today, OSHA issued a 32-page booklet on COVID-19. I've got a copy of that. It is a helpful read, but I'll have to confess, March 9th feels like it was about 6 months ago with everything else that's happened since then. The guidance does describe kind of 3 or 4 types of occupations. Low exposure, that's the person that's staying home or working from home or working out in the field by themselves. Medium exposure, which would be individuals working typically in an office environment where they're not coming into a lot of close contact with individuals. Could be a little bit more contact. And then you have high or very high exposure. Those are typically individuals in healthcare or related type jobs where there's a very high potential, or at least a high potential, that they could come in contact with individuals with COVID-19. The booklet also provides some pretty helpful guidance to employers about precautions they can take. I would suspect that most employers by now are taking those precautions either on their own or based on guidance they're seeing from OSHA or the CDC. OSHA does have a general, what we call a general duties clause that requires each employer to keep its workplace free from recognized hazards that are causing or are likely to cause death or serious physical harm to employees. And OSHA has said that COVID-19 is potentially such a hazard depending on an employer's risk exposure. Employers do have an obligation to abate a serious hazard. I suspect that most employers are doing that at this point. Haven't had this issue come up a lot. The biggest concern we've had come up thus far with our clients has been employees who don't want to come to work because of a generalized fear of being exposed to COVID-19. And I do think that the CDC guidance yesterday helps out with that, especially for industries that are essential. Make sure you're staying current with your CDC and DHEC fact sheets, especially if you have employees actually coming to work in person so that they can see those. It's just a good reminder to them of what obligations they have to make sure they self-report and social distance and that type of thing. This is one of those slides that I've got in here that, again, feels like it's about a month old, but abatement measures do include not allowing employees to conduct international and at this point, even most domestic business travel, providing PPP if needed. There's a lot of different guidance and opinions out there on the wearing of masks as a general rule in the workplace. I'm not going to get into that a whole lot today. If you've got specific questions about that, I'd be happy to try to answer them offline. And then requiring employees to stay home for 14 days upon return from travel to restricted areas. I don't think the CDC guidance from yesterday really changes that. But I would say that my suspicion is that most employers that are tuned in for this webinar probably don't have a lot of that happening right now just because of travel restrictions and budgetary restrictions and those kinds of things. Some additional abatement measures, require employees to stay home for 14 days. So this is where my slideshow got outdated yesterday afternoon. And so what we'll need to do is refer to that guidance from yesterday. But if you're in a non-essential industry, you may have this issue. But if you are operating, for example, if you're trying to fill orders for maybe home delivery or things like that, but your storefront's not open, I think these abatement measures would still apply. But if you're in an essential industry, I would suggest that you follow the CDC guidelines that were issued yesterday. Some additional measures requiring employees to stay home if they're sneezing or coughing or showing other symptoms. So in other words, they're not asymptomatic until the employee can provide return to work release. The EEOC has stated that employers can require that release from employees returning from a COVID-19 sickness. The EEOC has not clarified whether employers can require that type of return to work release in the event that the individual was not diagnosed with the sickness but was self-isolating or quarantining because of a suspicion or because of exposure. What I would say there, and what I've been telling my clients for the last month, is when in doubt, follow the CDC guidelines, because I think the EEOC or any of these other federal agencies would have a hard time taking an issue with any employer who followed the CDC guidelines. You can contact the CDC and state health departments if the employee develops COVID-19. That is not required. And we talked about this already, just cleaning and disinfecting the workplace. Restricting workplace visitors is a very good idea. You can use a questionnaire for those individuals who, if you are allowing visitors. And then providing telework options. That industry was already pretty active, but it's exploded over the last 3 or 4 weeks. We talked about the prohibition on retaliation already with OSHA's press release from yesterday, so I'm not going to get into that. I do want to talk briefly about that second bullet point. Section 13A of the Occupational Safety Health Act State's employee may refuse to work if he or she has a good faith belief there is imminent danger of death or serious injury, and that is true. We have seen some walkouts. I don't know that I've heard about this in South Carolina, but we have seen some walkouts, and as employers, you do need to know that a walkout would, because of a COVID-19 issue, is likely considered a protected concerted activity under the National Labor Relations Act, and that's true whether you are a unionized or non-unionized employer. And a walkout based upon conditions that the employees believe are abnormally dangerous to their health, that's something that is specifically covered under the National Labor Relations Act. All right, record keeping requirements. OSHA does typically exempt the common cold and flu, but COVID-19 is a recordable illness when a worker is infected on the job. So just make sure you're keeping your logs up to date. And this is a hypothetical that I had that I thought was a pretty good hypothetical until yesterday evening. I want to talk a little bit about it just so you can see the difference literally in 24 hours. So if an employee reports that he's not coming to work, because this is actually a phone call that I received earlier this week. Employee reports he's not coming to work because he's taking his wife to the ER due to COVID-19 symptoms. He worked in close proximity to 4 other employees yesterday. How should the employer handle that? And if you, in your slideshow, you don't have the red type that's in mine now. You'll see this when we circulate this later, but my answer now says, see April 8, 2020 CDC guidance. Yesterday, if you'd called me about that, I would have said send the employees home, advise them to consult with their healthcare providers regarding the length of time to stay at home, and follow the CDC guidelines on when to allow the employee to return to work. Now, you could still quarantine the work area and things like that. Well, now, if they're in an essential industry, you're going to want to look at that April 8, 2020 guidance that we talked about at the beginning, where we can allow them to come in. The CDC recommends that we take their temperature, confirm that they're asymptomatic, require them to wear a mask for 14 days, that type of thing. Non-essential, I would suggest that you still follow the guidance that I've got listed here on this on the slideshow that you see. That was given to you in the last couple, or I guess given to you yesterday. Skipping down towards the bottom, what about an employee who self-reports that they came into contact with someone who had a presumptive positive case of COVID-19? Before yesterday, in an essential industry infrastructure, it would have been the same advice as listed above there. Now that's changed with that guidance. And then that last bullet point, what about contact with third parties, which would mean customers or clients? We do want to know if close contact occurred, but if there was contact with customers and clients, you don't have an obligation to report that to the CDC, but depending on how practical it is, probably not a bad idea, especially if there was a lot of close contact, to try to let the customers and clients know in as confidential a manner as possible about that contact. All right. Let's talk about some wage and hour issues under the Fair Labor Standards Act. In 2009, the Wage and Hour Division of the Department of Labor issued a pandemic flu white paper about how employers should respond to a situation like we have now. The DOL has since issued a lot of guidance with respect to the FFCRA and some guidance on a few other on some other items related to COVID. I'm going to run through these some of these slides, just a lot of it stuff that you already know that I want to remind you of. But on wage and hour issues for your non-exempt employees, you're paying them still for their time they work. That's if they get paid. If they work more than 40 hours, you got to pay them overtime. You don't have to pay them for time not worked, even if they're ready, willing, and able to work, if you don't have work for them to do. If an employee is laid off or has their hours reduced, then obviously you don't pay them for that time. But I will say there are a lot of timekeeping challenges with employees working at home. Just because you have so much less control over how they're using their time. If they're sitting there reading a book, but they are on call, so to speak, because one of your clients may call them and it's during their regular working hours, then that's going to be compensable time. You can't refuse to pay those employees if they work a little bit overtime just because they didn't have prior authorization. That's still a disciplinary issue as opposed to a timekeeping issue. So just make sure you've got good procedures in place to try to monitor time for individuals working at home. For exempt employees, and here I'm specifically talking about the executive, administrative, and professional exemptions. As you know, you have to pay them on a salary basis, regardless of the number of hours they worked. As a general rule, if the employee performs any work during the week, they've got to be paid a full week's salary if they're ready, willing, and able to come to work. But that's not the case in their final week of employment. And I believe we've got a hypothetical coming up on this that we can talk a little bit more about that. Any type of work includes answering emails or phone calls. So if they work at home for 30 minutes in the morning, you're still going to have to pay them for that full day. If they're completely relieved of duty for a week, and this is true even if they're ready, willing, and able to work, but you don't have work for them, you do not have to pay for that week. And you can require your employees to use their accrued vacation or PTO for days off, even now during the COVID-19 situation. Partial week reductions in salary are not allowed for exempt employees, but one option is to prospectively make a decrease in the individual salary. We're seeing pay cuts across the board for a lot of entities. You can do that with exempt employees. You do want to meet the 7-day notice requirement in South Carolina. We'll talk about that on the next slide. But you can make future decreases in salary that correspond to reduced hours if the practice is occasional and due to long-term business needs. I would tell you, if you're planning to do that, go ahead and have a conversation with your employment law counsel, get some help walking through that process to make sure you do it the right way. In South Carolina, if you are going to reduce the pay of an exempt or non-exempt employee or significantly change their hours, reduce their hours, then you do have to meet the 7-day advance written notice requirement. Early on in this COVID-19 crisis, where we were seeing a lot of furloughs as kind of a knee-jerk reaction to what was happening, and I don't say knee-jerk in any kind of smart way. I mean that a lot of employers realized early on that business was not sustainable. But what are the consequences if you don't provide that notice? I got that question a lot. Look, I don't have time to wait 7 days before I reduce pay. In that situation, there is the first offense is basically a slap on the wrist written warning from the South Carolina Department of Labor Licensing and Regulation. And then after that, it's a $100 fine, $100 or $500. I should know that, but it's a $100 or $500. I believe $100 per occurrence violation. If you have employees in other states, be sure you know what type of notice requirements exist in those states with respect to changing the terms and conditions of employment. If you are asking your employees to work extra hours, and I do have clients that are doing that, they're very, very busy. There is no limit in the number of hours per day or week an employee can be asked to work, as long as the employee is 16 years old or older. You may want to consider morale and PR implications. You may want to consider hiring new people, but obviously you want to make sure you're careful about that. And that creates a whole litany of questions about what questions you could ask an applicant about COVID-19 exposure and that type of thing. You would also check your wage and hour laws in other states if you are going to be asking employees to work a lot more hours. All right, hypothetical on wage and hour issues. This is also a question that I received either early this week or late last week. An employer furloughed an exempt employee last Wednesday, but then recalled the employee this Tuesday. So they were out Thursday, Friday of last week after they thought they were after they were laid off. And then they were off on Monday and asked to come back to work on Tuesday. So how should the employee be paid for last week? And this is really kind of a trick question. So as you saw on a couple of slides back, an employee in this situation, if it's their final week of employment and they're exempt, an employer does not have an obligation to pay the employee their full normal salary, even if they're exempt, for their final week of employment. If the employer had, in this situation, my advice would be that if the employer had a good faith basis for believing that last Wednesday was the last day of employment and that individual was not going to be recalled for some period of time, probably more than 3 days, then the employer would probably be okay with just paying that employee through last Wednesday. In other words, a partial week's pay. What about for this week? I'd give you the same answer. Tuesday is when their first day of employment started back up. And so you wouldn't have to pay the employee for Monday. You would pay that pro rata amount of salary for this week. Got to be careful here. I know that this particular client that I was speaking with was in no way trying to get away with abusing the salary requirement. So I don't view this as an impermissible deduction, but I could make the argument on the other side as well on behalf of the employee. How about if the employee works every day next week except Thursday, but then isn't laid off or furloughed? They're just told that work's not available on Friday. Well, that exempt employee has worked part of the week. They're available and ready to work Friday. They've not been laid off, so the employer would have to pay the full amount. And then one more scenario, what if the employee worked Monday to Thursday next week, but then begins a previously scheduled FMLA leave on Friday? Let's say they're having knee replacement surgery on Friday. Well, they'd still be eligible for FMLA leave. It would be non-emergency Family and Medical Leave Act leave. In other words, wouldn't be paid FMLA leave. And therefore, the employer could choose to either require the employee or allow the employee to use PTO time or accrued vacation time. But the employer does not have an obligation to pay that employee for that time on Friday because there is an FMLA exemption or exception for a deduction in that case. And I've provided you a link there if you want a refresher on what are permissible and impermissible deductions. One more wage and hour slide, just some more tips on working from home. For your non-exempt employees, it is a good idea to set a specific work schedule and hours. Require them to record all their hours worked. We're asking our folks here at Nexen Pruitt to do that on a daily basis, so my assistant every day sends me. She actually sends me both a listing of her hours, and then she also sends me a log of what she's been doing all day, and I think that's perfectly fine. Require employees to provide advance written authorization for overtime, but if they don't and they work it, you still have to pay them. Prohibit working off the clock, including checking email, and you got to make a good faith basis or a good faith effort to do that. All right, let's talk real briefly about disability discrimination, and I'm just going to kind of go through some EEOC guidance. There was a lot of discussion early on with COVID about how what kind of questions employers could ask. Could they take employees' temperatures, those kinds of things. About 3 weeks ago now, the EEOC issued some guidance indicating that the ADA rules continue to apply, but they do not interfere with or prevent employers from following CDC guidelines. And that is a very helpful piece of guidance. And again, going back to what I said earlier, I think any of these agencies or plaintiffs' lawyers are going to have a hard time succeeding on claims against employers who follow CDC guidelines. Another question the EEOC addressed, during a pandemic, may an ADA-covered employer take its employees' temperatures to determine whether they have a fever? As you guys heard at the very beginning, the CDC is now recommending that those temperatures be taken for any individual who may have been exposed to COVID-19. Generally, that would be a medical examination, but in this scenario, the EEOC is saying, yes, that is okay. Also, the EEOC also addressed when an employer can and cannot exclude employees with disabilities from the workplace. The question there, may an ADA covered employer send employees home if they display flu-like symptoms during a pandemic? Yes. And again, the EOC there is following CDC guidelines, and that's what I've indicated there at the bottom. Just make sure you're following those guidelines. What about informing fellow employees of possible exposure? This is a question that I've probably answered 25 or 30 times in the last few weeks. But this guidance is helpful. If an employee is confirmed to have COVID-19, employers should inform fellow employees that of their possible exposure. So what I've been telling my clients is this is not something to broadcast to the world. You want to take the time to get information from that the employee that may have exposed other employees and ask them who they came in close contact with, and then you would identify you would inform those employees, but also maintain confidentiality as much as possible. The confidentiality thing has kind of become a joke in some ways because it's going to be pretty easy to figure out who the employee is fairly quickly. All right. I am going to go through the FFCRA materials really quickly. Like I said, I'm going to do this primarily so that if you have a question you want to ask at the end, we'll have touched on it. The Families First Coronavirus Response Act, applicable to employers with less than 500 employees. And again, this is something now that seems like it happened years ago, but it provides, the FFCRA provides paid sick leave and paid child care leave during the coronavirus crisis. Employers will be 100% reimbursed for paid leave. You know, we could do a 40 or 50 slide presentation on this particular law to provide guidance, but again, here we're just skimming through, just providing you some real high level information. The law was signed back on March 18, 2020, took effect April 1st, and it expires. It does have a hard deadline of expiration of December 31, 2020. In other words, the requirements will go away as of that date. Emergency Paid Sick Leave Act. So there were two pieces to, or actually more than two pieces to the act, but the two we care about the most for this presentation. The Emergency Paid Sick Leave Act covers any employee who works for any employer. No minimum days that they've been there. They could have been on the job for 2 days, as long as they're there on April 1st. No minimum hours of employment. And the law provides for 2 weeks or up to 80 hours of paid sick leave. That doesn't mean that somebody working part-time gets 80 hours of paid sick leave. The law does provide information or guidance about how to calculate the amount of hours that are payable. The Department of Labor last week issued about 120 pages of guidance on this law, and most of that guidance was devoted to just answering questions that have come up about how to comply with the law. The employee has to have a qualifying event, and there's a list of 6 qualifying events. They have to be unable to work or telework, and you can require an employee to telework. If they say they don't want to, that doesn't matter. You can still require them to telework. So the qualifying triggers are if the employee is under a government quarantine or isolation order due to COVID-19. What we have right now in South Carolina is not what I would consider a quarantine or isolation order due to COVID-19. If they've been advised by a doctor to self-quarantine because of COVID-19, if they're experiencing COVID-19 symptoms and seeking medical diagnosis, or caring for an individual subject to quarantine or isolation order, or advised to self-quarantine because of COVID-19. Items 2 through 4 get really tricky now because a lot of doctors' offices are, as you guys probably know, they're first requiring employees to do these virtual assessments. Sometimes employees can't get in, but they are symptomatic. So there's a lot of gray area there. What I will tell you is we got to handle each one of those situations on a case-by-case basis. And then the 5th item there in red, the employee needs to care for a child because daycare or school is closed and child care is unavailable due to COVID-19 precautions. The reason that's in red is that is the only qualifying event to qualify for the emergency FMLA leave, emergency paid FMLA leave. And then item 6, experiencing other similar conditions as determined by HHS. It is this temporary expansion. I'm going to run through that slide really quickly. The paid child care leave, as I indicated, it only applies to individuals who cannot work due to their school or child care facility being closed, and they also have to be the primary child care provider. We had this come up a lot early on where we were worried about abuse of this, where the individual employee was not the primary child care provider, but they wanted to take advantage of this and take some time off. And the DOL has provided some guidance indicating that they have to be what amounts to the primary child care provider. And that can be an intermittent thing. It could be a shared duty between parents. If you got questions about that, we can talk about that. And there is a new notice requirement. You can get the poster off of the DOL website there. And then let me spend I'm going to try to get through these unemployment slides in the next 5 minutes or so, and then I'll be happy to answer any questions you guys have, or at least try to answer questions. So unemployment claims in South Carolina by March 28th, which is now 12 days ago, we had 64,000 claims. We were expected to have 200,000 claims expected by, the slide says next week, but I believe that's by the end of this week. Dues already paid out $10 million in benefits just in that 5-day period of time last week. DUE has also stated that the $600 federal benefit that was part of the CARES Act will be paid retroactively for claims filed for the week ending 4/4. So basically anyone who is eligible for unemployment and filed a claim by April 4 is going to qualify for that $600 federal benefit. Just some information about DUE's initiatives, some ways that they're trying to cope with this. The governor has waived the 1-week waiting period to receive benefits, so employees that are furloughed or laid off due to COVID-19 issues are immediately eligible. They do not have to look for work, at least from the short term through the end of April while they're out. I believe that's going to be extended. And then COVID-19 claims will not affect the employer's experience rating. It is important for you guys as employers to make sure you're filing those claims initially for the employees if you are furloughing them due to COVID-19 issues. As employers, make sure your contact information with DUE is current. Also make sure you're responding to requests for information from DUE. You'll need to create an account on the website if you don't already have one. I will tell you that I've heard from many clients, you guys have probably experienced this, that the website is crashing frequently. I've described that as, they've had a several 1,000% increase in the amount of work probably that each person there has to do. So just be as patient as you can. I know that it is a frustrating process to go through. Just a real quick hypothetical that I want to walk through on unemployment and workplace safety issues. And again, I mean, this is some of this may go back to some of the CDC guidance from yesterday. An employee refuses to come to work or return to work from furlough due to a generalized fear of contracting COVID-19. How should the employer respond? So, one question you're going to want to ask under the National Labor Relations Act and under the General Duties Clause of OSHA is there a legitimate basis for the employee's fear or an imminent danger? If the answer to that question is no, then what happens if that employee refuses to come to work? That basically, I don't want to leave my house, I don't want to get sick, I don't want to be exposed to this virus or expose my family to the virus. Well, for an existing employee, is that a basis for termination? And I would tell you that the answer to that question is yes. And if the answer is yes, does it qualify the employee? Does that termination essentially disqualify? I know the slide says qualify, but does it disqualify the employee for unemployment? And my position on that would be yes, that the employer should contest that claim, because the employer has work available and the employee is refusing to come to work to do that work. Well, for a furloughed employee, can the employer require the employee to return to work as a condition of continued employment? Yes. I mean, the answer to that question is yes as well. You can require that even if they have this generalized fear about COVID-19. If they refuse, what's the impact on their unemployment for that furloughed employee? So they're out. The scenario here is they're out. They're receiving benefits. They're receiving unemployment, but you've now called them and said, we're ready for you to come back to work. Maybe you're calling them and asking them to come back to work because of a PPP loan, and you're going to be covering the payroll that way. And you've got to make sure you're covering it because you want to be, you want your loan to be forgiven, or you're able to, you just have work for them to do. If they refuse, then they're refusing to come back to work. Then you, as the employer, will want to let you know that that has happened, so that that employee no longer qualifies for unemployment benefits. All right, one more hypothetical, and we'll be done with the slideshow. Employee refuses to return to work because they want to draw state and federal unemployment. I think I might have covered this a minute ago, which in many cases will exceed the employee's regular earnings. That will be a very common scenario with the $600 federal benefit. Can the employer require the employee to return to work as a condition of continued employment? The answer to that is yes. If the employee refuses, what is the impact on employment? And again, that's where the employer will want to let you know about the employee's refusal to come to work, because that is a disqualifier for unemployment benefits. So that's the slideshow. I think we've got at least 5 or 6 minutes. You guys listen fast, so that's good. And I'm happy to try to answer any questions you may have now.
Okay, so I've got, just so in case you didn't hear earlier, if you have questions, you can go in and type them into the questions box, and we'll get them and moderate them through. If you can't do that, there should be an option for you to raise your hand, and we can call on you that way, but we prefer them to be in the question box. One of them comes and says, has anything changed for insurance for anyone laid off as a result of COVID-19? In other words, does COBRA apply as normal? Since furloughed employees can keep their insurance, will they need to pay for it by check while they are furloughed and at the same rate, not the COBRA rate?
A lot of questions in that, and I should have been taking some notes. I'll try to answer that. So as you guys probably know, most of the big carriers have given a lot of they provided a lot of guidance to employers and a lot of leeway to employers about continuing to provide benefits to employees, even though they're not actively at work. So you want to check with your insurance provider. But my understanding is that in most scenarios, with the employee who is furloughed, the employer will be able to continue their health care benefits, and that the layoff, if it's due to COVID-19, is not a COBRA qualifying event, and the employee can continue with their group health coverage. Now, premiums, I'm not a tax lawyer. I do some employee benefit work. My understanding is that the IRS has issued guidance indicating, in conjunction with the CARES Act and with FFCRA, that the employer can recoup its cost to pay its share of premiums and even the employee's share of premiums while the employee is out on furlough. I hope that answers that question. If it doesn't, feel free to follow up. I may eventually give you an I don't know, though.
All right, and then we've got one that's referencing your slide number 31. The employee who chooses to stay out for up to 12 weeks allowable due to child care issues. If they're paid by their employer for 2 weeks, can they file unemployment for the remainder of the time that they're out?
Okay, read that to me one more time.
An employee who chooses to stay out for up to 12 weeks allowable due to child care issues. They're paid by the employer for up to 2 weeks. Can they file for unemployment for the remainder of the time out?
Okay, the employee, and I'm going to go back to slide 31, so please excuse that. Actually, that's not 31, is it? Mine changed. I believe it's
Yeah.
this one.
There you
Okay.
go.
So an employee who has to be out, who qualifies for the emergency paid FMLA leave, they're going to qualify first for 2 weeks of paid sick leave under the Emergency Paid Sick Leave Act. And then if they have to continue to be out for the next 10 weeks of that FMLA leave, that leave is paid by the employer. The Department of Labor has issued guidance indicating that an employee who's receiving those benefits, either the emergency paid sick leave or the emergency paid FMLA leave, would not be eligible for unemployment. After 12 weeks, if the employee is still unable to return to work, there is no job protected leave. The employer would not have an obligation to continue to employ the employee, and the employee could file an unemployment claim. I will tell you that I'm not sure how DUE would handle that claim.
All right. And then we have, we're conducting temperature checks outside before an employee enters the building. Is the time considered work time under the FLSA? So I guess, are they do they count the time they're out there checking temperatures as clock in time?
Yeah, there's been a lot of discussion about that over the last 2 or 3 days, and there's going to be more of that with the CDC guidance. My opinion on that, but I can't base this on specific guidance that I've seen. My opinion, my advice to an employer would be to treat that as compensable time. If it is de minimis for all employees, meaning, it's just going to take employees 1 or 2 minutes each at the start of the shift to have their temperature checked, then I would opine that it's not compensable. But if there's a line of people waiting 10, 15, 20 minutes before the shift starts to get their temperature checked so they can start their shift on time, then I would treat that as compensable time.
And then I think we've got 2, 3 more, real quick. One is, I think this is referring to the part where you were talking about people having a reason not to come into work, and if you could let them go for that or not. What about employees who say they are more susceptible to getting the virus because they have like immune deficiency issues and don't want to come back to work because they're fearful of that?
Yeah, that's a great question, and it's one I've heard a handful of times. I've had somebody, I think, with lupus. I've had some other folks with autoimmune type issues who are susceptible, who would be more susceptible to infection. I think you need to treat that on a case-by-case basis. I could make out a pretty good argument that you're discriminating against somebody on the basis of a disability if you require them to come to work under those circumstances.
And then as a restaurant with less than 50 employees, if you've been closed since March, they're now interested in, since March 22nd, we're interested in starting a curbside pickup to go. They would bring staff into work less than 20 to 25 hours per week. Would they still qualify for unemployment benefits?
Yeah, that's a good question too. The short answer is that the individual would have to get paid, and whatever they get paid, they would report to DUE, and DUE would make that determination. The South Carolina formula for determining benefits is so complicated that I really can't get into a discussion about that, but I would caution you that if they're making more than a couple $100 a week, then there's a pretty good chance that they're going to be disqualified. And if they're disqualified from receiving state benefits, they'll also be disqualified most likely from receiving the federal benefit.
All right. In discussing the Family First guidelines, that still excludes employers with greater than 500 employees, correct?
That's correct.
All right. Are administrative, direct care, and housekeeping employees in a healthcare long-term setting considered under the critical infrastructure workers with the interim guidance?
Read that to me one more time.
Are administrative, direct care, and housekeeping employees in a healthcare or long-term care setting considered under the critical infrastructure workers with the interim guidance?
Okay. I wish I could interact a little bit more, but so I'm gonna treat that 2 ways. Under the CDC guidelines, I would say yes, And then under the South Carolina guidelines, I would say yes. Now, I know that's the same answer, but I'm not sure why the question is being asked. The reason I want to clarify is if it's under the South Carolina executive order or under any other state's order, it is helpful for employers to provide documentation to employees of their critical status, essential status, so that I don't think this is happening much in South Carolina, but in the event that they were stopped by law enforcement and asked why they were out of their home, they would be able to provide information about that.
All right, and the last one, if a company doesn't have FMLA due to having less employees, are they concerned with the FMLA part of everything?
Yeah, so that's a good question. The FFCRA expands FMLA to employers of any size. Doesn't matter if you meet the 50 employee threshold. So the slide I just flipped to, you can see that eligible employers, any with fewer than 500 employees, and for just this purpose. Now, this doesn't apply to any other FMLA leave, but for this purpose, and I've got my mouse here. For this purpose, it's anyone with fewer than 500 employees, not just 50 employees within a 75-mile radius.
Jamie, this is Angele. We want to thank you so very much for spending an hour of your time with us and sharing the knowledge that you have. I want to thank you for joining us on the call. Appreciate everybody who was able to be with us. I want to remind our participants that you're going to be receiving a follow-up email that will contain a survey. And if it'll just take a couple of seconds to complete that, that will assist the Chamber in providing you with some programming, future programs, webinars that we can help to meet your needs. A recording of this presentation will also be sent out along with the updated PowerPoint presentation that Jamie's going to send us. And the recordings will also be uploaded to the Chamber's website under the COVID-19 resource page. Again, Jamie, can't tell you how much we appreciate your knowledge and your expertise. So thank you very much.
Sure, glad to help.
Okay, everybody have a great day. Please don't hesitate to contact the Chamber if you have any suggestions or ideas of what we can do to assist you. Thank you.